Hey.
Hello. Bank of New York, Mellon against Cine UK Limited. 13 months of pandemic, and only now do we finally have a case on whether COVID-19 is a reason for tenants not to pay the rent anymore.
3 tenants in the case: Cine UK, Sports Direct, and Mecca Bingo, and they were all saying for various reasons we shouldn't have to pay their rent. They shouldn't have to pay their rent. So they relied on the express rent cessor clauses that they all had. But they said if these don't work, we want to imply rent cessor clauses. And then they said the landlord's got obligations to resort to their insurance, and then frustration, temporary frustration, illegality. So they're about those are 5 arguments. And then they also said if the landlord hasn't complied with the code of practice, the landlord and tenant code of practice, then that's another reason why, not why rent shouldn't be paid, but why this shouldn't be dealt with by summary judgment, essentially.
Right.
But all of those arguments failed.
There was this argument that the rent cessor kicks in because a pandemic is damage to premises. Obviously it's damage to premises, it's financial damage to premises, and so the rent cessor kicks in on the normal drafting. What happened to that?
Yeah, so they all argued that, and all the tenants were stuck with the same problem, which was the rent cessor clause said there's a rent cessor if the premises is damaged or destroyed as such that it becomes unfit for occupation, and basically that argument was just rejected because damage was limited to physical damage.
Why should damage be limited to physical damage? I don't understand.
Natural and ordinary meaning.
No.
Duh.
So isn't it? So it sounds to me like the tenant's 1-0 down, and has probably had a couple of men sent off, some of the weaker players, but actually the game's not over yet.
If you find that a helpful way of understanding it, then okay.
I do, yes.
I mean, the points that aren't really considered in any detail are this issue about when a
Take
tenant...
off 5:30 on top.
Sorry, I'm not bored. I'm listening.
Save lives and relegate COVID-19.
Talk like this.
Oh, there's an advert about COVID. Oh, sorry, that doesn't. Yeah, sorry.
When the issue about when there's no actual legal prohibition on opening, but for commercial reasons the tenant chooses to close,
Yeah.
or chooses to reduce its opening hours, there's no real consideration of whether that has an impact.
Right. Oh,
And that was actually relevant on the facts. But some of the places could have legally been open but were closed because there was very low footfall, or everybody's working from home still.
Right.
There's not really a consideration of that issue because it all turns really on this physical damage point. And then also implied term. I mean, there are other implied terms. For example, the argument that other tenants are running, it's an implied term that if you can't use the premises for their full intended purpose.
Yeah.
That wasn't argued. That
Wasn't it?
specific implied term wasn't
Right.
argued.
You see, what I want to argue is that an implied term is when an officious bystander that's hypothetical, that you imagine standing there when the lease is negotiated, if asked, is this term part of the bargain, would say yes, of course, and be testily suppressed by the parties. Right? That's the test. And if an officious bystander was standing there when most retail premises were being negotiated, the leases of them, if the officious bystander was to ask, is rent still going to be paid if these premises can't be used because of a global pandemic, which means that legally they have to be closed and there's no footfall and therefore no turnover, the parties would say, of course not. Of course it can't be used. The whole purpose of the let is the footfall.
But Master Dagnall says no. You must be talking to a different officious bystander, because Master Dagnall said that his bystander would say, well, it would just be there'd just be scope for negotiation. There isn't an obvious term. In that situation, there is no obvious conclusion.
The whole point of the let is footfall. The whole point of most lets, that's why it costs more to take premises in Oxford Street than it does to take premises in the middle of the countryside, because of the footfall. So the whole purpose of the let is footfall. No footfall, no purpose, no rent. What's so amazing
So
about
your implied term would have reference to footfall.
Yep, the footfall must be at or around the level of that which pertained at the date of the
No, that's just
entry
silly.
into the lease.
So if the business is going down because nobody likes to play bingo anymore, then
Yeah, but
what,
maybe
you don't have to pay your rent?
maybe footfall for other things. Yeah, if you're selling a rubbish product, sure, but it's footfall generally. Footfall in that locale, because all leases are about, all retail leases anyway, are about footfall.
Well, Master Dagnall says if they wanted that term, they should have put that in.
That's never an answer. Anyway, we're here now. It's time for you to get out, in which case I can carry on arguing with myself without fear of contradiction and being told that my thoughts do not coincide with those of Master Dagnall. I still think there is room for manoeuvre. So goodbye. I will see you in due course, preferably before the next judgment on rent arrears.
There won't be any more.
Yes, there will.